Muscovitz.
May it please the court, Mark Tinker on behalf of Matthew Muscovitz. I'd like to reserve 5 minutes.
Okay.
The primary issue in this case is something that has been somewhat of a developing area of the law in recent years, and that is when you have these admitted liability situations where the defendant admits that they were negligent in causing the accident. When does a jury have to award, at the very minimum, the cost of initial diagnostic testing or a trip to the emergency room, those sorts of things? There have been a few recent opinions. I know Judge Davis was originally supposed to be here with us today. He wrote the most recent one for this court. It was Martin versus Brubaker. And then the most recent opinion on it just came out of the 4th District. That is the Hernandez versus Gonzalez case. And I think if you look at those cases and what they examine, it is that it essentially goes back to what is the fundamental issue with negligence trials and what a jury is instructed to do. Is they're instructed to award damages reasonably incurred. So the question is, if the jury looks at the circumstances before it, can they decide whether this initial diagnostic testing, whether it be a trip to the emergency room, a visit to a medical clinic the next day, 2 days later, was that reasonable under the circumstances for the plaintiff to do that? And I think in this case, there was evidence that the jury could have decided this was not a reasonable trip to the emergency room, and therefore it could have properly awarded the verdict that it did, which was one of no liability. And just looking at the situations, this was, the Hernandez case was actually one where the plaintiff was transported from the scene by ambulance to the emergency room. But the court said, there was evidence that when she was there, people saw her laughing and joking around. She did not appear injured. So the jury could have properly said, even those expenses, the ambulance transport, is not a reasonable damage incurred. In this case, we have a plaintiff who, from the accident scene, there was testimony that did not appear injured, did not claim he was injured, left the accident scene instead of going to an emergency room, denied medical treatment there, went on to visit his girlfriend for a while. Eventually, later that day, did go to the emergency room, but he, by his own testimony, said that he primarily did so because he had his young daughter in the car with him. She was not yet verbal, she couldn't communicate whether she was injured, so he primarily wanted to go get her checked out and make sure she was okay. While he was there, decided to get checked out himself. Tellingly, the test said he had normal range of motion, no problems. The thing that he sued for eventually was a herniated disc in his neck. At the emergency room, did not complain about his neck whatsoever. The only thing he said is he thought he had a foot problem. But at trial, he did not seek any damages for his foot.
So as a rule, if he goes to the hospital for a legitimate concern about the foot, if that's not what he ends up suing for, Zippo.
Well, he didn't seek any damages for the foot at trial, so the jury was never asked to award that. So,
but he is your rule he would be precluded from making a claim about the foot if he didn't complain about the neck at the emergency room?
No, I don't believe he would be precluded from. He just didn't in this case. If he had gone to trial and said, I have a herniated disc in my neck and I want damages for that, and also I hurt my foot in the accident, and at the very least I should get damages for that, then he...
The fact that he did not make a claim at the emergency room about his neck, is your rule that then precludes him from anything at trial? No damages.
Well, that would allow the jury to say, did he, this is what he's seeking. The jury could say, was it reasonable for him to go to the emergency room for this, when that's not what he went to the emergency room for. So the jury could say, no, that was not a reasonable trip to the emergency room for your neck because you didn't go there complaining about your neck. You didn't have a neck issue at that point. So it's the jury tying it basically it's an issue of causation, the jury tying it to the auto accident. So again, I think you look at, there was evidence here that the jury could have said, given all of the factors that he went there primarily to get his daughter checked out, that his tests were normal, there was expert opinions that he did not receive this neck injury in the accident, he had degenerative conditions, diagnostic films did not show any signs of acute injury. The jury heard about the minimal nature of the impact. This was actually a 3-car accident. Mr. Muscovac hit another car that was in the middle as sort of a buffer car and pushed that car into Mr. Schultz. So there was very minimal damage, light impact. All of these things, the jury could have properly decided that this was not reasonable for him to seek any care. And at the very least, I think the second issue, we've got the first one is, did the jury have to award at least that diagnostic care? And then the second issue is, when we got to the point where the judge granted a new trial, could he go as far as to do what he did and say new trial on everything, all of the damages? Because there at the very least was, again, direct expert testimony that there was no permanent injury, that it did not cause this neck condition. And that, at the very least, was supportable by the evidence, and the judge can't come in and essentially veto that and say we get to try the whole thing all over again now.
Well, tell me what the judge meant when the judge signed the order, and I'm going to assume this is Demers writing this himself, that the jury was deceived as to the force and credibility of the evidence or influenced by considerations outside the record. Can you tell me where that came from?
Well, to start with, you're saying you assume that was Demers writing it. That was not Demers writing it. That was obviously an issue that went back and forth in the briefs a little bit. That is actually a direct quote out of the motion for a new trial, and that was an order. Is that in the record that the attorney for the plaintiff submitted that?
Correct. Okay. And you didn't get a chance to dispute the content. Was there a motion for a reconsideration and say, Judge, let's talk about this verbiage? What did you mean by that?
There was initially an order, but there was the hearing where the judge announced on the transcript, the judge announced, I'm granting a new trial based upon, and it was the Martin versus Brubaker, and I forget the Kolsky case that Judge Altenburn wrote. He said, I'm granting a new trial based on that, which are the initial diagnostic treatment cases.
And that was the second phase of his order.
That was what he announced at the hearing. That was his.
The order is teed up as the second prong.
Correct. The order, the original order that was circulated by, the judge said, plaintiff's counsel circulated an order. The original one granted a new trial on all 4 issues that were raised in the motion, even though the judge never addressed 3 of the 4. That was objected to, and so counsel submitted both that order and the one that the judge ultimately signed, which contains that language. But again, that's cut and paste language from the motion for new trial. Those weren't the judge's words. The judge's words at the hearing were that he was basing his decision based upon Martin and Kolsky, saying the jury had to award at least initial diagnostic testing because this was admitted liability and there was a trip to the emergency room.
It's when you say considerations outside the record, normally there's some argument, this influenced them and this is improper. But I don't see any itemization of what these considerations outside the record were.
And I don't believe that there was anything. That was never, as far as, and again, I'm not being trial counsel from me just looking at the record as you would, there was nothing at the hearing that was argued about, this happened that influenced the jury.
So it's a presumption by the judge. If you couldn't give damages in this case, you must have been drinking a Kool-Aid and looking at something else. That's the way it's written, the way I'm thinking about it.
I believe so, and I believe that that's the way that the 2 cases that the judge relied on are, is these are people that were involved in an accident, admitted liability, transported directly to the emergency room. The court said, well, how could that not be reasonable diagnostic care under those circumstances? But then you look at, again, the Hernandez case out of the 4th District, which said, well, you have to actually do this on a case-by-case basis and look at the circumstances. Even somebody transported directly by ambulance, if there's evidence that the jury could hang their hat on, so to speak, that at the emergency room she's laughing, giggling, joking around, doesn't appear hurt.
But the judge was hung up on the fact that the jury was instructed to award full damages and not to subtract something like the ambulance or the ER care. And then you started talking about a remedy, and the judge gave everything a new trial. And I think you were about to say there might be a way to limit the remedy to just some out-of-pockets.
And I think that's exactly what this court's precedent is in both Martin and Kolsky. The remand was, it said, well, causation has already been decided. The jury decided there was no causation for this neck injury. And that's the same thing that happened in both Martin and Kolsky. And this court said, okay, even though the jury was not allowed to award 0 damages, causation's already been decided, so you don't get a second bite of that apple. But you have to remand for at least the minimal damages. And I know in both of those cases, I believe the plaintiff asked for an additor or a new trial, and the opinions aren't quite definitive as to whether it was an actual full trial as to what's the cost of this emergency care, or whether it was just an issue of an additor. But even in those cases too, it might go beyond the emergency care. I suppose there could be, initial treatments, maybe a couple visits to a chiropractor or whatever the case may be. So that would be what the scope of the new trial is. But you don't go back and get to try causation for this herniated disc and potential surgery and permanent injury and trying to beat the no-fault threshold. All of those things have inherently been decided by a jury already, and they've unquestionably been properly decided because there was direct expert testimony that this is not a permanent injury caused by the accident. So the jury decided that, and that's proper. I think in this case, the jury's entire decision was correct because of the fact that there was evidence that it could say this initial diagnostic care wasn't reasonable. At the very least, there was evidence that this is not a permanent injury caused by the accident, so they don't get to go back and retry everything. I think the 2 remedies I'm seeking is, first, obviously, a reversal to reinstate the jury's verdict because this is proper based upon the evidence that was presented at trial, or at the very least, this new trial order should not be just new trial as to everything. It should be new trial as to what is the cost of the reasonable diagnostic care that followed this accident. And again, I think that's the primary issue. I would be otherwise just repeating the arguments in my brief, so I'd reserve the rest of my time unless the court has any questions.
I'll save you the 5 minutes you asked for.
Thank you.
Good morning.
Good morning. May it please the court. My name is Nick Shanine, and together with Ronald Kraft, we represent the appellee in this matter, Walter Schultz. Despite the repeated argument to the contrary, this is a case about the broad discretion that trial courts have always, time immemorial, been imbued with to determine that a matter should receive a new trial. That is precisely what Judge Demers ordered, and that is exactly what this court should affirm. The argument has consistently been from the opposing side that, but there's competent substantial evidence that could have possibly sustained the jury verdict. The Supreme Court of Florida, back to Cloud v. Paulus, back to the estate of Stuckey v. Brown, and the most recent decision, Van v. Schmidt, cited in the appellant's own brief, all continue to repeat these very important standards by which the courts repeat that competent substantial evidence, even if it exists for the other side, isn't enough. That the judge is empowered with the ability to look at the case and go, this doesn't add up. In the totality of my experience as a judge, I'm allowed to decide under very particular circumstances that this doesn't work.
You're saying the judge gets to second guess the jury if the judge thinks they just got it wrong, even though you just said if there's competent substantial evidence to support the jury's verdict.
The standards.
So then we never have a final judgment that a jury can never say that's our judgment and it stands. It always can be set aside by a judge.
That is the power that is instilled in a trial court under those circumstances where a judge finds that a miscarriage of justice has occurred. In this instance, there is a 40-year-old man who had never had any trauma to his back, who had never had a prior accident, who had been rear-ended in an accident, had every single physician he went to, including a physician the day of the accident, the physician that he went to the week after the accident, the physician he went to a month after the accident, the MRI that showed bulging at 5 different disc levels, that each of these doctors all said the same thing: you're hurt.
But there was a question of fact as to causation. I mean, you agree with that?
Well,
some people argued that's pre-existing. Some people argued that's post-accident.
Well, and that's precisely the point, though, Judge, is that while a jury would otherwise be imbued with its own fact-finding discretion, if a judge is convinced as he sits there, that clearly something happened where that jury did not consider the totality of the evidence, the manifest weight of the evidence, and that's of course the phrase. It's not that there can't be a scintilla of evidence that could possibly say support a defendant's affirmative defense through summary judgment. If that were the standard, then no court could ever grant a new trial, and instead the Supreme Court has said, and this was the recent words of the Florida Supreme Court in Van v. Schmidt, that this court has repeatedly held that the trial judge has broad discretion in ruling on a motion for new trial on the grounds that the verdict is contrary to the manifest weight of the evidence. A trial judge has the responsibility to draw on his or her talents, his knowledge, and his experience to keep the search for the truth in a proper channel. And the trial
Tell
judge...
me what the judge meant by that phrase I asked Mr. Tinker about, that the jury was deceived as to the force and credibility and influenced by considerations outside the record. What was he referring
Certainly.
to?
Well, there's no mystery that part of the primary theme that was put on by the defense was, aha, the very day after this accident, our plaintiff shows up at a trial lawyer's office. And then these doctors start to say this and this and this.
Did that happen?
That was the argument that was included.
But was it a factually correct argument about the sequence of events? Went to the lawyer after. So I mean, the aha thing really is not necessarily untrue. It's just pointing out a fact in the history of the case.
That is correct, Your Honor. The thing is, if that is what the jury relied upon in making its decision, that we don't like trial lawyers. We think anybody who goes to a trial lawyer the day after an accident and must clearly have issues that aren't real issues, if that's what a jury's relying on, and it takes that trial judge's experience, and Demers obviously has vested years of experience, and these aren't rulings that I don't find any reversals of him on new.
Well, I mean, the countervailing argument would be it's not open season on people that legitimately get hurt in an accident just because they went to a lawyer. They have the prerogative to go to a lawyer, and that's a countervailing argument I'm assuming both sides took and made to the jury, and the jury figures that out.
Well, it is to an extent, but of course it's a difficult thing for a plaintiff's attorney to directly address that head on. It requires more tact than perhaps is frankly possible.
But then that would be your ace in the hole. I'm just saying,
right.
Then if you don't get a good verdict, they just don't like going to a lawyer. We get a new trial judge.
We'll get a new trial only if a judge agrees that in the totality of his experience, because he was the one who got to see the witnesses. He's the one who got to, which is why the appellate courts have always said, hands off on a motion for new trial. Unless no reasonable judge, and that's the standard, the Kanakaris standard of no reasonable judge is the standard that this court is bound to follow, that unless this court believes that Demers so missed it, not a single other judge, not a single other reasonable judge, would have possibly found that this was contrary to the manifest weight of the evidence. Unless this court is willing to say that, the trial court's ruling should stand, that the motion for new trial was argued. There was no written opposition to the motion for new trial. There was no motion for reconsideration following the order that came out from the motion for new trial. That this order should stand and this court should affirm. As to the Hernandez case that's been cited, there are numerous distinguishing factors between Hernandez and the instant case.
I mean, the order does look suspiciously like snippets of the motion.
And Your Honor,
it doesn't look like the judge actually typed that himself.
I'm not going to debate, Your Honor, that the judge asked for proposed orders, received the proposed orders from the plaintiff. He actually received two different proposed orders, chose one to his liking. The cover letter that was included with it said, if there are any other changes you would like me to make, I'll be happy to do so.
What the judge actually said at the hearing, is there anything in the order that mimics what the judge actually said at the hearing?
Certainly. The judge said at the hearing that the totality of the verdict was against the manifest weight of the evidence. Those were the judge's words. That the judge didn't say, I think that this was against the manifest weight of the evidence solely to this one issue or this one issue. He referenced that, well, I find these cases persuasive, Brubaker and Koletsky. But then he went on with an additional paragraph that said, I find the totality of the evidence to be against the manifest weight of the evidence. And so he ruled that a trial on new damages would be appropriate. The judge could have limited it to something else, and because of the great discretion that's invested in trial judges to do this one specific task at the end of a jury trial, we certainly could not have argued contrary to if the judge had elected to limit it, but that was the judge's discretion. Appellant can't make that call, we can't make that call, and this court shouldn't invade the province of a trial judge who has been imbued by this discretion that has been repeated time and time again. The Florida Supreme Court had to revisit the entire issue of, well, gosh darn it, what are trial judges supposed to do, or what are appellate courts supposed to do with trial judges' orders on granting a new trial? And they went through and they said, everything that's in Cloud, we're going to quote it in large blocks, in our opinion. Everything that this court said in Stuckey, we're going to quote that in large blocks, in our opinion. That we're going to hold that the trial judge's discretion permits the grant of a new trial, although it may not be clear, obvious, and indisputable that the jury was wrong. That's the Florida Supreme Court in 2013 saying that is what we believe appellate courts should do with rulings by trial courts regarding orders for new trial. That where the evidence clearly was all on one side, that the weight of the evidence, the totality of the evidence, the manifest weight of the evidence showed that we have a 40-year-old man who's never been in an accident, who's never had any significant trauma to his back, who didn't have surveillance on him, didn't have, like in Hernandez, an expert for the defense in Hernandez opined that the plaintiff had suffered from a pre-existing condition and stated that the accident didn't contribute or cause that medical condition. Here, we have a defense doctor show up who says, yeah, I'm going to find that the neck is related, and I'm going to find that at least 3 months of treatment is reasonable and necessary. That everybody was on page except for the jury. And for a judge to weigh in and decide this is the rare but important time for me to perform my role as a judge, to be that backstop that the Florida Supreme Court says I'm supposed to be, to ensure that justice is done, that should be upheld by this court, and we respectfully request this court to affirm the motion for new trial as ordered.
All right, thank you very much. Rebuttal?
Essentially the entire argument has been about the judge's discretion, and I think there's a big difference between a judge exercising his discretion and a judge second-guessing what a jury did based upon legitimate evidence that was presented and essentially deciding to disagree with the jury. And, you know, there's all discussion about how great the plaintiff's evidence was and how there were all of these things. Well, I just talked about what the defense evidence was about how there was no treatment at the scene, how there was a doctor who said no, this was not.
But was there a defense expert who said some portion of the injury was related to the accident?
He said that he thought some 3 months of conservative treatment would be appropriate, that it was not a permanent injury caused by the accident. There was a radiologist who said, looking at the diagnostic films, there was that herniated disc was not an acute injury, that there was degenerative changes there.
Well, the jury gives $0. How do we fix that?
Well, the jury is entitled.
Can that be bootstrapped to the judge saying, well, you know, there's a question of fact, even the experts don't necessarily disagree on all portions of the case. To a point they agree, and then beyond that there's a big dispute.
Well, I think it's well established that even in cases where the experts agree as to one aspect of it, even if it's just that minimal care, that juries, if there is other competent evidence for them to essentially hang their hat on, they can say, no, we don't really believe the experts. They're instructed to that exact thing, that you can give those, you know, the experts' opinions the way that you believe. You can reject them if you want based upon the other evidence in the case.
Including the defense expert.
Correct. Even if there's, and that is the Van case is one of the more recent ones that says exactly that. That was a case where there was all of the experts, including the defense expert, agreed that there was some injury caused. The jury said no, there wasn't. And the court said the jury was entitled to do that based upon not only its instructions, but obviously the other evidence in the case. It can look at the force of the impact. It can look at whether there was treatment at the scene, whether they complained of injury at the scene, and, you know, all of the other factors that go into this, whether there was pre-existing conditions, as here there was documented, documented degenerative changes in his spine. The jury can look at all of these things and decide to reject expert testimony. And I think the key here, again, is this was argued as, well, the judge is the backstop. He can decide to step in. Not if he's disagreeing with the jury about a disputed issue. That is not the trial judge's role. It is not, you know, if their experts are a priest and a rabbi, and ours is an ex-convict, and the jury goes with the ex-convict, the judge can't come in and say, you know what, I was at a trial, nobody could believe that guy, you have to believe these other two. That's what the judge essentially did here, because there was competent evidence that supports the jury's verdict. The judge stepped in and said, you know what, I believe the totality of the evidence should have gone the other way. If I was sitting on the jury, I would have decided with them. That's not the judge's role. The judge's role is to make sure there's a fair and impartial trial. That occurred here. The evidence supports what the jury did, including all of the things that I've listed.
All
Is
right.
there any other questions? Thank you.
Well, good. Thank you very much.